it is with the specific feeling of the responsibility that falls upon a counsel and advocate that I appear before you today. My task will be to expose the vision of Myanmar regarding the applicable law on the merits of the case. The parties seem to agree on the fact that the 1948 Convention is the law applicable to the merits. Indeed, Gambia had, in its memorial, made scattered references to international customary law. But those references have disappeared from its reply, as they have from their pleadings that we heard this week. One might conclude that its claims are now only based on treaty law. When it comes to the Convention, major divergences in the views of the parties bear on the meaning to be given to its core provisions, especially Article 2, which defines genocide, and Article 3, which lays out the different types of responsibility that may arise under the Convention. The parties lend a different scope to Articles 4 and 5, bearing on the obligations to punish those responsible for genocide and to set up the appropriate legal framework. I will devote my presentation today to Article 2, and I will cover the other provisions next week. But before I consider the interpretation of these terms, allow me to make some cross-cutting comments. The first is that it is clearly established that the regime of individual responsibility and the regime of state responsibility for genocide are two distinct institutions. To quote your 2015 judgment, state responsibility and individual criminal responsibility are governed by different legal regimes and pursue different aims. The former concerns the consequences of the breach by a state of the obligations imposed upon it by international law, whereas the latter is concerned with the responsibility of an individual as established under the rules of international and domestic criminal law, and the resultant sanctions to be imposed upon that person." End quote. This duality when it comes to responsibility remains a constant in international law. You said it in 2015. And it has consequences when it comes to the interpretation and application of the underlying criteria. Thus, determining genocidal intent does not follow the same logic or the same conditions whether one is attempting to attribute it to an individual or to a state. Since it is a mens rea, the physical or the matter of whether one is dealing with a natural or legal person has an influence on the in-criteria application of such a criterion. Also, if a single murder could be enough to sentence an individual perpetrator for the crime of genocide, it is inconceivable that it would be enough to establish an actus reus that could be attributed to a state. As a consequence, the taking into account of international criminal jurisdiction must be done with careful consideration and not automatically, as Gambia would suggest. Now, it is certainly not an easy task, nor a necessary one for that matter, to put together a general theory of how international criminal jurisprudence is to be taken into account. But it is certain that your court intends to preserve its autonomy in its interpretation of the Convention and its autonomy in the in concreto implementation of its provisions, without ignoring, but also without paying excessive deference to the judgments of international criminal jurisdiction. And once again, I quote the 2015 judgment of the court. It is for the court, in applying the convention, to decide whether acts of genocide have been committed. The court will take into account, where appropriate, the decisions of international criminal courts or tribunals in examining the constituent elements of genocide." End quote. Besides, when the court called upon the jurisprudence of the ICTY, it was to confirm its own reasoning. It did so to determine the abstract meaning of some provisions of the Convention, or to assess how a specific factual situation was to be qualified in light of the criteria thus set out. As opposed to the current case, or rather, as opposed to the Bosnia and Croatia cases, in the present case, the jurisprudence of international criminal courts is relevant only for the abstract interpretation of the Convention, because no criminal jurisdiction has to this day ruled on the facts put before the court. I won't show the same conclusion for the jurisprudence of domestic courts called upon by the Gambia and some intervening states. That has to do with the practice of the states concerned. While it certainly is legal practice, it is nevertheless unilateral. Thus, these domestic decisions have all the more reason not to be considered subsequent practice within the meaning of Article 31(3)(b) of the Geneva Convention on the Law of Treaties, that they do not actually amount to application of the Genocide Convention itself. At the very most, they could amount to application of the corresponding national legislations of the states of the Forum in all their nuance, or rather in all their nuances, which Myanmar has laid out in its written submissions. I therefore do not see how these domestic decisions could be authoritative in the eyes of the court. Members of the court, Myanmar holds to your jurisprudence in matters pertaining to interpretation and application of the Convention dear, and especially the 2007 and 2015 judgment that my team will be quoting frequently. However, and despite emphatic assurances to the contrary, the Gambia intends to overturn this jurisprudence, allegedly because it is too restrictive and would make it impossible to provide the proof of genocide. Some intervening states say the same. Some of them call it into question explicitly, as Slovenia does, or they do it implicitly by putting forward interpretations that sensibly differ from yours. This attempt to overturn, or at least significantly change the jurisprudence, is flagrant, at least in three ways. When it comes to establishing the content and the proof of dolus specialis, when it comes to defining the very notion of group, and regarding the identification of acts that might make up actus reus. And I will be showing this in the rest of my speech. At this stage, I believe it is important to recall two guiding principles that have guided the court's interpretation, or rather application, of the Convention. The first of these is legal certainty. Under that principle, and in general, the court does not choose to depart from previous findings, particularly when similar issues were dealt with in the earlier decisions, unless it finds very particular reasons to do so. Here I was quoting your 2015 judgment. in the present case, neither the Gambia nor the intervening states have identified these very particular reasons that should lead you to depart from your jurisprudence. The second guiding principle that I would like to highlight has to do with the specific rigor that one must follow when assessing the existence of genocide. In the 2007 ruling, you adopted the considerations of the appeals chamber for the ICTY in the Krstic case, and I quote, "The gravity of genocide is reflected in the stringent requirements which must be satisfied before this conviction is imposed. These requirements, the demanding proof of specific intent and the showing that the group was targeted for destruction in its entirety or in substantial part, guard against a danger that convictions for this crime will be imposed lightly. Where these requirements are satisfied, however, the law must not shy away from referring to the crime committed by its proper name." The same goes in the present case. The court is called upon to examine the Gambia's allegations with the rigor required by the gravity of the accusation made. There must be rigor when analyzing the criteria for genocide. There must be rigor when dealing with the facts of the case. And finally, when it comes to proof. My colleagues, Mr. Christopher Steiker and Professor Talmant, will tackle the latter two aspects. For my part, I will cover the criteria to establish genocide as established in Article 2 of the Convention. And to quote your well-known definition that the Gambia also referred to on Monday, genocide contains two constituent elements. The physical element, namely the act perpetrated or actus reus, and the mental element or mens rea, unquote. Stemming from these considerations, I will first be examining the convergences and divergences between the parties relating to the appreciation of dolus specialis, and then those relating to actus reus, all the while highlighting at each stage the interplay between these two constituent elements. Regarding dolus specialis, the parties agree to consider dolus specialis as the essential characteristic of genocide, which distinguishes it from other serious crimes. The chapeau to Article 2 defines it as the intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. Similarly, the parties seem to agree on the fact that the expression "intent to destroy" means a will to physically or biologically destroy the group, even though in practice the Gambia is actually attempting to broaden the spectrum of actus reus. But it is quite obvious that acts such as the destruction of the cultural identity of a group or an intention to make a group disappear from a given geographical area are not equivalent to physical destruction. Thus, even if it were to be established, quod non, the enforced displacement of a population or even ethnic cleansing do not constitute in and of themselves genocide, because the governing intent to such operations is not to destroy the group physically or biologically, but to move its members outside of a specific area in order to make that area ethnically homogeneous. As opposed to what the Gambia alleges, the mens rea of ethnic cleansing can therefore not coexist with genocidal intent. They cannot coexist at the same time. Since dolus specialis is central to the definition of genocide, the court does not solely analyze it as a separate constitutive element, but instead also considers the actus reus in the light of this concept of destruction which appears in the chapeau of that provision. This approach was made explicitly in the Croatia case. Having recalled the meaning of the notion of destruction of the group at the beginning of paragraph 136 of the judgment, the court concluded at the end of that paragraph that the notions of serious harm that appear at letter B and the forcible transfer of children that appears at letter E should be considered, and I quote, as referring only to acts established with an intent to bring about the physical or biological destruction of the group, end quote. The concept of physical or biological destruction found in the chapeau therefore influences the identification of the actus reus of Article 2. The different types of behavior listed are genocidal when they are of a nature to destroy a protected group in whole or in part. There is therefore an interlinkage between the two constitutive elements, even though the Gambia obscures this entirely by alleging that the two elements are analytically independent.
Pourtant, la Cour a insisté d'une manière, je cite à nouveau l'arrêt de 2015.
And yet the court has generally insisted on this interdependence. And I quote, although analytically distinct, the two elements are linked. The determination of actus reus can require an inquiry into intent. In addition, the characterization of the acts and their mutual relationship can contribute to an inference of intent. End quote. By trying to separate the analysis of both these aspects, Professor Sands on Monday only mentioned the beginning of that quote, namely, although analytically distinct. The subsequent words goes against this affirmation of autonomy. It follows that Gambia is also wrong in stating that the scale of allegedly genocidal behavior has no impact on the determination of genocide. It also claims that the killing of one person may come under Article 2 of the Convention. This is, however, hard to reconcile with the obligation to demonstrate the intent to destroy physically the group as such. In fact, it is an illustration of the unavoidable pitfalls of automatically transposing the jurisprudence of international criminal tribunals to state responsibility. Indeed, the following judgments, Tolimir from the ICTY and Nyeziyama of ICTR, which Gambia refers to, relate in fact to the criminal intent of an individual, not to that of a state. Both courts considered that individuals had taken part through the limited number of killings that could be attributed to them in a broader general genocidal enterprise which had clearly been identified in previous judgments of the same courts. Despite the attempts by Gambia to sow confusion, your jurisprudence is very clear. To establish genocide on the part of a state, the scale of the destruction comes into play. And it is not a frivolous and cynical approach to state that. But let me quote your 2015 judgment, and more specifically the part entitled Scale of the Destruction of the Group. And I quote, "Since it is the group, in whole or in part, which is the object of the genocidal intent, the court is of the view that it is difficult to establish such intent on the basis of isolated acts. It considers that, in the absence of direct proof, there must be evidence of acts on a scale that establishes an intent not only to target certain individuals because of their membership to a particular group, but also to destroy the group itself in whole or in part." End quote. I can, of course, only agree with the phrase used by our colleagues on the other side of the aisle, that genocide is not a numbers game. Indeed, it is not a game at all. Yet, the scale of the destruction does count. It counts in the determination both of the dolus specialis and of the actus reus. When seeking to attribute killings or other genocidal or other acts of genocide to a state, there must be a sufficient number of victims relating or resulting from a coordinated campaign and not from a series of isolated acts. The scale of destruction is the reason and gives the measure of the exceptional gravity of genocide, the crime of all crimes. Let me move on to the idea of destruction of a group in part. Now, I may be lecturing you somewhat, but it does seem that my colleagues across the aisle do seem to interpret the judgments of 2007 and 2015 in a way that goes against the letter and spirit of these judgments. And this is particularly true of the way the identification of part of a group and the expressions of genocidal intent are entangled. The scale of the destruction is analytically different from the substantiality of the part of the group. The genocidal intent must focus on the group as such, as we have seen. And at the same time, Article 2 specifies that genocidal intent may target a protected group in whole or in part. And this word, substantial, was used by the court to qualify the part of the protected group and not the size of the scale of the destruction. And the very logical organization of sections in the 2015 judgment leaves no room for doubt here. Section 1 is entitled The Meaning and Scope of Destruction of a Group, and it includes two subsections. The first one relating to the physical or biological destruction of a group, which describes, or defines rather, destruction. And the second refers to the scale of destruction of a group, and that is therefore something related to the scope. And then there's section 2, entitled The Meaning of Destruction of the Group in Part. And the words in part are what is covered in that section. And in that context, the court therefore considered that the word substantial relates to the targeted part of the group. And if you look at the syntax, that clears up any remaining doubt. And still in the 2015 judgment, you find the following. The intent to destroy in part the protected group relates to a substantial part of that group. And further on, the court recalls that the destruction of the group in part, within the meaning of Article 2, must be assessed by reference to a number of criteria. In this regard, it held in 2007 that the intent must be to destroy at least a substantial part of the particular group, and that this is a critical criterion. So it's the part of the group that is being targeted that must be substantial, not the destruction as such, but destruction must indeed be of a sufficient scale. So we have two different aspects of dolus specialis here. The part of the targeted part of the group must be substantial, but it must also be identifiable a priori, thanks to positive characteristics. And in the Genocide in Bosnia case, court identified a number of objective elements that may be taken into account to identify a part of the group. And they were summarized in the Croatia judgment as follows, and I quote, "In evaluating whether the targeted part of a protected group is substantial in relation to the overall group, the court will take into account the quantitative element as well as the evidence regarding to the geographic location and prominence of the allegedly targeted part of the group." End quote. The court's jurisprudence therefore combines a quantitative approach, so the ratio of the part over the whole, and a qualitative one. Thus, the Muslims in Srebrenica were a substantial part of the group of Bosnian Muslims because, according to the determination of the court, they had a considerable strategic importance and were representative of the group as a whole. So that's the qualitative criterion. Gambia, by fueling the confusion between the scale of the destruction and the identification of the substantial part of the group that is being targeted, seeks to hide these ambiguities. The applicant, therefore, does not mention whether the genocidal intent it attributes to Myanmar relates to the destruction of the group in whole or in part. It simply uses as a mantra the following sentence: destroy in whole or in part the Rohingya group as such. Gambia also ignores the identification of the part of the protected group that is allegedly being targeted, and it uses none of the objective criteria that have been stated in your jurisprudence. Regardless, it makes many references to the targeted part of the group, without ever mentioning the objective criteria which would help identify it. On Monday, Professor Sands gave assurances, and I quote, "The targeted part of the Rohingya group was substantial," without further details. He merely identified 3 settlements, Minji, Chutpin and Mongnu, where the damages was significant, but they made no attempt at trying to demonstrate why that population made up a substantial part of the protected group within the meaning of the convention. And then immediately afterwards, he extended this assessment to the whole of the group living within Rakhine State. Generally speaking, the applicant also refers to the victims, even though they cannot be considered, and I quote the 2007 judgment, cannot be considered as a collection of people who have a particular identity. Over the course of the week, Gambia tried to outline typologies and types of victims by focusing more specifically on the situation of women and children. But there again, without giving any thought to whether such ad hoc categories may meet the criteria identified by the court to identify a substantial part of the group. Gambia's method, or rather the lack thereof, undermines the analysis of dolus specialis. Indeed, if the whole group is being targeted, then Gambia needs to give a direct or indirect proof of the intent to destroy the entire group of Rohingya of Rakhine states. If it is a substantial part of the group that is being targeted, it must prove the dolus specialis against that specific substantial part. This proof necessarily depends on the specific circumstances and specific acts targeting that substantial part. However, the failure on the part of the Gambia to identify the allegedly targeted substantial part of the group distorts any line of reasoning that would aim at establishing dolus specialis on the basis of the circumstances. Scaling up now. The Gambia does not identify the substantial part of the group that is concerned, but it merely examines dolus specialis and actus reus for a part, and then concludes that the entire group as a whole has been destroyed, or is being destroyed. And in so doing, the Gambia extends its conclusions on a few isolated acts to the entire Rohingya group.
Monsieur le Président, j'en viens maintenant à la manifestation du dolus specialis.
Mr. President, I now come to the manifestation of dolus specialis, which is probably one of the most dividing legal questions in the present case. The parties are putting forward radically different views on this matter, and the intervening states are each bringing nuances and changes to the standard and method of proof that emerges from the court's previous judgments. These differences in approach have to do with the perpetrator to which the dolus specialis must be attributed and the manifestations of dolus specialis inter alia via so-called lists of genocidal indicators. First off, dolus specialis must be attributed to a state. And for a state to be responsible for genocide under the Convention, it is not sufficient for specific individual perpetrators to have acted with the specific intent required to make them individually criminally responsible. The state itself needs to have had genocidal intent. Logically, intent cannot take up the same form and expression when we are dealing with the will of an individual or that of a state. Thus, in the Croatia case, the court stated, and I quote, "The dolus specialis is to be sought first in the state's policy. Alternatively, the dolus specialis may be established by indirect evidence, that is to say, deduced or inferred from certain types of conduct. The parties disagree, however, on the number and nature of instances of such conduct required for this purpose." In these extracts, the court states that the dolus specialis must be found in the policies or the intention of state. It recognizes that this policy or intention will rarely be expressed explicitly, and it admits that the existence of a policy or state intent can be inferred from the individual behavior of the perpetrators of the given acts. This being the case, however, the intention of states cannot be confused with that of individuals whose behavior might be taken into account to potentially identify a genocidal pattern of conduct. In the Bosnia case, the court did not either examine whether there was a genocidal intent on behalf of individual soldiers. It clearly indicated that it was not up to it to determine the individual criminal responsibility of anyone for such acts. The court rather tried to determine whether there existed a policy, a plan, or a genocidal intention among the leaders of Republika Srpska. The only place where the court decided that genocide had been committed was in Srebrenica. And to draw this conclusion, the court considered that a policy or an intent was established in the Republika Srpska army itself, rather than simply in the soldiers that made it up. The court agreed with the ICTY conclusions in the Krstić case, according to which the military staff of the VRS had targeted the Muslims of Srebrenica, the military staff, not individual members of the military. The Gambia equates the intention of an individual to that of a state in order to claim that there can be coexistence of genocidal intent and a legitimate aim. In the present case, the will to remove ARSA from the settlements where anti-terrorist operations took place. To do this, it refers haphazardly to criminal jurisprudence that refers to personal motives of individuals as, and I quote, the prospect of individual economic gain, political advantage, or a certain form of power, end quote. When it comes to individual intent, motives can coexist with genocidal intent, but this distinction between genocidal intent and personal motives cannot be transposed to the intent of a state. Nevertheless, that is what Mr. Reichler attempted to do on Wednesday at the expense of some bending of logic. By considering the motive to be an eminently personal and individual fact, he stated that
personal or political, and may include, for example, to defeat an insurgent force such as ARSA. Ainsi, la Tatmadaw et les forces de police du
Thus, the Tatmadaw and the Myanmar police forces allegedly were a tool to serve a few military officers, and the operations in 2016 and 2017 against ARSA are allegedly just a politician's maneuver. On what is such speculation based, we cannot say, and Mr. Reichler continues.
And specific intent were complementary. The ostensible object of defeating ARSA was pursued by means of a deliberate destruction of the Rohingya group. Fin de citation.
End quote. I have great consideration for such an eminent member of the bar, but this would amount to say that the state has decided to solve congestion in a city by doing away with its entire population. On a theoretical level, that does not seem reasonable to us. Mr. President, I will now say a few words about proof by inference and the theory of genocidal factors or genocidal indicators. According to the Bosnia judgment, and I quote, the dolus specialis has to be convincingly shown by reference to particular circumstances. And I shortened the quote. For a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent. Here also, our interpretation and that of the Gambia diverged considerably. According to the Gambia, indirect proof by inference can be done through two alternative methods. Specific circumstances or systematic pattern of conduct support a will for destruction. Nothing allows us to consider that the court promoted two alternative methods. And if the extract from the Bosnia case that you have on your screens were not clear enough, that of 2015 also provided useful clarifications in paragraph 145, all the while quoting paragraph 373 of Bosnia. The court in 2015 states the following: "It is necessary, in the court's view, to clarify the process whereby such an intent may be inferred from the individual conduct of perpetrators of the acts contemplated in Article 2 of the Convention. The parties accept that intent may be inferred from a pattern of conduct, but they disagree on how this pattern should be characterized, and on the criterion by reference to which the court should assess its existence." The circumstances of the Bosnia case are those that allow us to identify a pattern of conduct in the individual behavior of the perpetrators of genocidal behavior. Circumstances are not intrinsic characteristics of some topical behaviors, as the Gambia states when it refers and insists on the alleged brutality of military operations or to the perversity of alleged acts of sexual violence. Indeed, the very fact of attributing genocidal meaning to isolated acts, to consider that they are established quod non, would run counter to the principle according to which proof by inference cannot stem from isolated acts, but at the most from a systematic pattern of conduct. And it is the circumstances, all the circumstances, that might potentially allow the court to identify genocidal intent in a state. Thus, the theory of genocidal indicators or factors put forward in the Gambia's memorial before it is leaved out in its reply and then brought up again with great insistence in the pleadings, this is not based in your jurisprudence. There's no basis for it there. The court has never drawn up a list of genocidal indicator, and for good reason. It would no longer be the specific circumstances and overall circumstances of a situation, but a pre-established list of criteria that might establish the existence of genocidal intent. And this would run counter to the very logic of proof by inference.
Admittedly, the Gambia seemed to rely on the Croatia judgment, but it distorts the court's reasoning. Let me remind you that the court had suggested that Croatia had suggested in that case a series of 17 factors which it believes, individually or taken together, could lead the court to conclude that there was a systematic policy of targeting Croats with a view to their elimination from the regions concerned. Now, when it responded to this argument on the part of Croatia, court reviewed 5 and retained them. These were mentioned by Mr. Reichler on Monday, even though he only mentioned 4. But that doesn't really matter because these factors were not considered to be decisive by the court. In fact, the court did not look at them as autonomous factors of genocide, but took them into account to establish the systematic pattern of behavior. Then, even before it opined On the dolus specialis, the court went on reviewing the context of the attacks and the opportunities of destruction. Context was used by the court to establish the purpose of the Serbian army. In this case, the systematic assault on populations inhabited by Croats and enforced displacement. The court found that the purpose was either to produce ethnically homogeneous populations or to punish the population. It was not a genocidal purpose. On the other hand, the opportunity, and I agree with Professor Sands, the word is unfortunate indeed, but the opportunity was had to review the systematic nature of the facts. And the court looked at whether the armed forces used these opportunities to destroy the group when it had physical control over the areas. And the answer was significant and key in excluding dolus specialis. So, in fact, the court, in the end, came back to the standard of only reasonable inference. And in that respect, the theory of indicators of genocide has not been successful in the eyes of the court, even though it was an easy shortcut to avoid the difficulties of assessing dolus specialis in the light of the entire circumstances. In the first round of pleadings, the Gambia mentioned or made a practical application of this theory with its checklist of the 7 deadly sins, if you want to call them that, as drawn from the findings of the FFM. Do these actually refer to specific characteristics of genocide, or are they only the unfortunate constituent parts of awful international crimes? I think the answer is pretty obvious. These indicators rely heavily on the 17 criteria put forward by Croatia. And even though the Gambia states that the FFM's indicators are deep-rooted in jurisprudence, in fact, a number of them were rejected by the court as being irrelevant, and that was done in 2015. And looking at it in the list that was excluded, we're looking at the insulting, derogatory, racist and exclusionary utterances of Myanmar officials and others, the government's tolerance for public rhetoric of hatred and contempt for Rohingya, and the existence of a discriminatory, which the court excluded under the second Croatian indicator. Then the court also rejected the existence of discriminatory plans and policies, as it also included the state's failure to investigate and prosecute violation. All of these were not relevant to establish a systematic pattern of conduct. Ladies and gentlemen of the court, these indicators are only the illustration of the law of the hammer, according to which it is tempting, if the only tool you have is a hammer, to treat everything as a nail. Similarly, when the qualification of genocide is the only one that gives a jurisdictional basis, it may be tempting to qualify as indicators of genocide the details you seem to identify in a given set of circumstances. Mr. President, the standard to establish a dolus specialis is and remains undoubtedly that of the only reasonable inference. The existence of genocidal intent must be the only reasonable explanation for a pattern of conduct identified by the court. Professor Talman will come back to that this afternoon. But can I say that by trying to impose in the discussion a supposed list of factors of genocide, the Gambia is trying to establish a presumption of dolus specialis, and it is all too visible in its pleadings. Since Monday, we have only heard little mention of concrete facts, but have heard extensive mention of the FFM's findings and conclusions. They were indeed the guiding thread in the arguments. The indicators of genocide have been used to justify a presumption of dolus specialis. They were also qualified as being specific circumstances necessarily leading you to find a genocidal intent. The systematic pattern of conduct that is used by the Gambia as an alternative to the method of the indicators of genocide has the same aim and same purpose, namely to impose on Myanmar the duty to reverse the presumption. And our colleagues across the aisle have been very clear. Let me quote Professor Sand.
Conduct of the clearance operations targeting Rohingya villages, it was merely undertaking counterterrorism operations, cannot therefore serve of itself to rebut the existence of a genocidal intent.
Rebut the existence of genocidal intent. That would mean that Myanmar should now show the lack of genocidal intent. The court cannot follow the Gambia's lead at the risk of agreeing to an unacceptable reversal of the burden of proof. Indeed, it would no longer be incumbent on the applicant to prove genocidal intent, but on the respondent to disprove it. Let me now move on to the last point in my presentation, actus reus, and I will take up less time. The only acts that may come under actus reus, the material element of genocide, are those listed under subparagraphs A to E of Article 2 of the Convention. The list is a comprehensive one, which the Gambia recognizes in theory, but in practice it is trying to broaden its scope and discusses at length alleged conduct which cannot be said to come under actus reus. This is particularly true of the allegedly discriminatory laws and practices and of hate speech. It is not clear whether the Gambia considers these alleged conducts and behaviours as satisfying actus reus, but it does contend that they surely contribute to establishing evidence of dolus specialis. Can I, however, remind us that in the Croatia case, the court did not deem them as relevant. Can I also mention another major disagreement between the parties on actus reus, and I mentioned that at the top of my presentation. Contrary to the Gambia, Myanmar considers that each of the material elements identified in the provision must be looked at in the light of the dolus specialis found in the chapeau. They must therefore be such as to destroy the protected group in whole or in part. The material elements must therefore have a specific degree of gravity and a specific scale. And there again, the court's jurisprudence is very clear, and again I'll refer you to the Croatia judgment. The acts listed in Article 2 of the Convention are prescribed inasmuch as they are directed against the members of the protected group and reflect the intent to destroy that group in whole or in part, end quote. Now, on the basis of these cross-cutting comments, can I make a few brief comments on every one of the material elements mentioned in the present case? As concerns the killings of members of the group under subparagraph A, the parties agree that this refers only to the intentional or deliberate killing, that is, the intentional killing of members of the protected group. But the Gambia rejects the logical consequence thereof, and that is that the legitimate homicide of insurgents or terrorists during an armed conflict or during policing operations is not killing under the Convention. Civilian casualties that were not deliberately caused are not killings either within the meaning of the Convention. Moreover, killing within the meaning of the provision must lead to the destruction of the protected group, and this is due to the interaction between dolus specialis in the chapeau and the material elements, the actus reus, but also the murder of members of the group. Contrary to the assertions of the Gambia, a small number of killings by a single perpetrator or by a few perpetrators, absent the broader campaign likely to lead to the destruction of the group, cannot satisfy actus reus under subparagraph A. Subparagraph B, the serious bodily and mental harm must also be such as to contribute to the physical or biological destruction of the group in whole or in part. The parties seem to agree on this in the written phase, but Professor Sands, I believe, came back on this by insisting that the widespread sexual crimes, or the more so when committed against children, are deep and lasting causes of pain for the victims, and undeniably so. But pain is not being denied when the pain of victims is not being denied when we recall that it is in itself it is not enough to include sexual crimes when established within the actus reus of genocide. In the Croatia case, when looking at the word serious, the court concluded that sexual abuse come under actus reus when they are such that they contribute to the physical or biological destruction of the group in whole or in part. As concerns subparagraph C, deliberately inflicting on the group of conditions of life calculated to bring about its physical destruction in whole or in part, the relationship with dolus specialis is clear and transparent in the wording itself. In the Croatia case, the court specified, and I quote, that the conditions of life must themselves be methods of physical destruction whereby the perpetrator ultimately seeks the death of members of the group, end quote. In the very same case, the court considered that rape, deprivation of food and medical care, systematic expulsion from houses and forced displacement, restrictions on movement and forced labour could only come under subparagraph C if they were deliberately being inflicted on the group with a view to bring about its physical destruction in whole or in part, or if it could lead, or if it could have such an effect. Under subparagraph D, measures intended to prevent births within the group. That too must be interpreted in the light of dolus specialis found in the chapeau. These measures must therefore have been adopted with the intent of ultimately causing the destruction of the group and must be objectively such as to achieve that. And I'll quote again the court in the Croatia case, it is necessary that the circumstances of the commission of these acts and their consequences be such that the capacity of members of the group to procreate is affected, end quote. As concerns administrative measures aiming at regulating the births, the Gambia states that they may be a part of actus reus, insofar as they would have been adopted with the intent of preventing the group from perpetuating and reproducing. That is wrong. In law, we have to establish that the capacity of the members of the group to procreate is affected. Mr. President, can I also call on the great Raphael Lemkin? I found the reading of Chapter 9 of Access Rule very instructive, and it's never too late to read it. It showed me the gap between the birth of an idea on the one hand and its crystallization in a legal concept on the other. Indeed, the Convention does not entirely match Raphael Lemkin's ideas and conception, although it does use the same words and the basic raison d'etre, namely the requirement to protect a group as such against the threat of destruction. But the Convention did not go along with the idea of a cultural or social genocide as proposed in Chapter 9, nor did it go along with the approach on the basis of indicators of genocide. Maybe this is too pedestrian a statement, but we have to come back to the letter of the Convention. Mr. President, this brings Myanmar's first session to an end, and members of the Court, I thank you for your kind attention.
Statement brings this sitting to a close. The oral proceedings in the case will resume this afternoon at 3 p.m., when Myanmar will continue its first round of oral argument. The sitting is closed.